Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed both in Texas and in Wyoming. And in this video, I'm going to talk about a really popular question relating to trusts. Now, in another video, I talk about what is the role and responsibility of a trustee of a trust. And then in another one, I talk about what is a beneficiary of a trust. But in this one, I'm going to talk about the settlor. And sometimes you'll hear that term settlor used instead of trustor or grantor of a trust. And that all means the same thing. So settlor, grantor, trustor all means the same thing. And what that is the person who initially established the trust. And more specifically, the person who initially funded the trust or put assets into the trust. So if you're the person who's going to an attorney to create a trust, you're the settlor, you're the trustor. And that means sort of you're kind of most in charge. Usually the settlor has the power to amend the trust and to make many decisions about the trust document itself, but not necessarily manage the assets. That's the trustee. So the trustor or settlor is the person who established the trust and often has reserved the right to make certain changes to the trust document, but they're not necessarily in charge of dealing with the management of the assets or making distributions to the beneficiaries. Now, usually when we do a revocable living trust for our clients in place of a last will and testament, our client is the settlor, obviously, but they're also the initial trustee, and they're also usually the beneficiary. So what that means is during the client's lifetime, so long as they have mental capacity, they're in charge of establishing the trust, putting assets into the trust, managing those assets for themselves. So what that means is if they transfer the ownership of their residence into their trust, they can make decisions about what happens to that residence in the future. So they can modify the rules under that trust agreement, but they can also use their powers as trustee to sell that home and buy another home. Basically, they could do whatever they want so long as they are settlor, trustee, and beneficiary. Now, the role of the settlor really never changes. Once that trust is established, you will always be the settlor of that trust because you will have always been the person who initially established and funded that trust. So, in other words, even if you're incapacitated or deceased, technically you're still the settlor. It was established by you. So the trusteeship might change if you're incapacitated or deceased. You may no longer be a beneficiary if you're deceased, but you will always be the settlor of that trust because you're the person who created the trust. Anyway, I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney licensed to practice law both in Texas and in Wyoming.